Let's take a look at the second degree intentional homicide statute. So if one of those affirmative defenses apply and they're able to drop it from that first degree into a second degree, then we're going to jump into this different statute, which is what is in the Wisconsin law. Whoever causes the death of another human being with the intent to kill that person or another is guilty of a Class B felony if the state fails to prove beyond a reasonable doubt that the mitigating circumstances did not exist as required by 940, which is the previous subsection. So here's this is a lot of work, but here's how it works. Kyle goes into court and he says, yes, I did shoot that person, all those people. I did intend to shoot all of those people, but this is not intentional murder. This is not murder. This is something where I believed that I was under, an imminent circumstances where my death was going to occur or substantial bodily harm was going to occur to me. Therefore, I am sort of exempt from that first degree intentional murder statute. The government has to come back and say, well, what were those circumstances? So Kyle is saying, here are my circumstances. It's an affirmative defense because I was being chased. They were threatening to kill me. They were, surrounding me from every which way, every angle. They all had, many of them had firearms. They were making verbal threats to me, all of those things. Then he can use that and say, that's my defense. Yes, I killed him, but that's my defense, which is pretty reasonable. So then the government now has to come back and say, yes, but none of those factors existed. They actually weren't chasing you. They actually weren't threatening you. Or if they were, none of that amounted to what would otherwise be considered an imminent, reasonable threat of death or imminent injury to your body. So that's going to be a pretty big question, and we're going to see whether or not that comes up. There is another statute here that is really, really big. It's really long. I don't want to spend too much time on it, but we will fly through it here because it is important. We're talking specifically about the Wisconsin statute that defines what self-defense is. And here's what it says. So bear with me as we read through this. A person is privileged to threaten or intentionally use force against another for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his or her person by such other person. All right. So you're allowed to use reasonable force if you're going to be preventing somebody to be interfering with his or her person by somebody else. The actor may intentionally use only force or threat as the actor reasonably believes is necessary to prevent or terminate the interference. The actor may not intentionally use force which is intended, this is where it's important, or likely to cause death or great bodily harm unless the actor reasonably believes that such force is necessary to prevent the imminent death or great bodily harm to himself or others. And so when we talk about the word reasonably is something that a normal, standard, average person, anybody in that person's position would do under the circumstances. It's supposed to be an objective standard versus a subjective standard. So let's say that we're not using reasonably. Let's say that we swap Kyle Rittenhouse out, or we start looking at his situation and we say, yeah, well, he's 17 and yeah, he's this and yeah, he's this and yeah, he's this. So we're going to change the law to apply to 17-year-olds and kids with firearms and kids, all these things. That's a subjective standard. Right now we're saying if there was another person in Kyle's shoes, would he reasonably believe that such force is necessary to prevent the imminent death or great bodily harm to himself or to herself? And from what we've seen here today, I think that answer is a resounding yes, right? This is something from what we've seen thus far where this person felt like he was being threatened, felt like he was about to be attacked or killed. But we don't know about that first video just yet. We don't know what happened there. We don't know if he was being threatened at that time. And the self-defense statute is only going to apply to imminent death or great bodily harm. You can see that the statute itself does not talk about any other type of property, right? You cannot use intentional force or deadly force if it's going to be to anything other than imminent death or great bodily harm. But from what we saw on that second video, I think he is going to be able to invoke that second statute. Let's keep going with the statutes because the self-defense statute is very, very, very big. It's a very long statute and it does not read very easily, but let's run through it because I think this is where a lot of the legal arguments are going to come down to. It's going to come down to self-defense and to provocation. So let's dive into this. If an actor intentionally used force that was intended or likely to cause death, this is from the same statute, it's from this one here, 939-48, or great bodily harm, the court may not consider, this is important, the court may not consider whether the actor had an opportunity to flee or retreat before he or she used force, and shall presume that the actor reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself or herself if the actor makes such a claim. Okay, what does that say? In other states, there is a duty to retreat. Before you can use deadly force, you got to run away. That is not the case here. The court may not consider whether the actor had an opportunity to flee. So many people in this situation are going to say, well, maybe at least to the first incident, he shouldn't have ever fired his gun. He should have run away. That's not the case here. This is the situation where if he felt like he was under imminent threat of physical injury or death, he's not required to run away. He doesn't have to go away. If he's only there to protect property and he's not under threat from this rioting, mob of people, then it doesn't apply. But if it's something that it goes directly to his concern for his safety or well-being, he can then use deadly force. He's not required to run away. I think that's going to be a big criticism from a lot of people who are protesters, pro-rioters. They're going to say, yeah, well, he shouldn't have even been there and he should have run away and all of those things. Sorry, that is not the case. This is somebody who has a right to stand in public property. It's somebody who has a right to have a firearm. And simply because he's there, that's not illegal. I've seen some other posts and things about that gun was illegal. I don't know that that's the case. I think the Wisconsin statute says he's allowed to open carry. I don't think he was in violation of any laws here, but that could change. But if we're just looking at these statutes and we're saying if an actor feels that there was something that was threatening him, he's not required to run away. The statute goes on a little bit further. It says that if somebody else was unlawfully or forcibly entering the actor's dwelling or motor vehicle or place of business, then some other things apply. So if somebody was trying to break into Kyle's car, break into his house, this would also not require him to retreat. So I think that actually goes in strong favor of Kyle's case, because from what I've seen, it does look like there was, some threats, a lot of threats kind of surrounding him. The statute goes on even further, and it says that the presumption does not apply to any of the following types if the actor was engaged in criminal activity or was using his or her dwelling to further a criminal activity at the time. So what is this saying? If an actor had the intentional use this force, they're not required to flee away. The court shall presume, this is the presumption that they're talking about, that the actor reasonably believed that this stuff was necessary. So there's a presumption here which strongly favors Kyle. It says that the court is going to just presume that the actor reasonably believed that the force was necessary, which is a pretty big presumption. That means that Kyle doesn't have to go and prove that. And I think it's pretty obvious from the video anyways, but he's not going to have to go and prove that. The court shall presume that that justification existed. That is unless, however, the actor was engaged in criminal activity. This subsection gets rid of that. If they're engaged in criminal activity, then you don't get to suddenly now rely on self-defense. In other words, if you're breaking the law and somebody's coming after you for that, you don't get to suddenly claim self-defense. So I don't see anything here that really hurts Kyle's claim.